Yes.
My lord, can leave to mention one application, my lord, it was returnable today. My lord, application for vacating, my lord. Suppressing material facts, my lord, the petitioner approach.
Returnable today.
It was returnable today. It is not appearing in his lordship's list. The urgency is there, my lord.
Please hand over this.
Get
They can Yes.
So technically, senior, my lord.
May I seeking your lordship's leave to move, my lord, one urgent civil revisional application. Application under section 161 for holding Durga Puja, which I was doing for last 15 years. Which I was doing for last 15 years by the order passed by the same Lord Learned Court. But this time it has been refused. But the urgency is, Lord, if by this week I could not able to, Lord, hear out this revisional application.
When have you filed the civil revision?
No, Lord, I am seeking your lordship's leave to file, Lord, so that, Lord, I can give the, Lord, date to day after tomorrow. Because 48 hours, beyond 48 hours.
Day after tomorrow is 48 hours.
That's no, Lord, 48 hours means today if I file, I will have to give, Lord,
what is the difficulty, Mr. Mukherjee, if you move on Thursday?
Lord, Lord, there is no caveat. Your lordship has to direct me to serve. If I can come back by this week, because
only one day, Mr. Mukherjee, because some cases, because they have to take time for the scanning and other things.
Because of the, Lord, the puja or nothing else, Lord. If by this week I could not able to, Lord, get some order, Lord, thereafter I will have to apply for police, Lord, the clearance from the police authorities.
You have the certified copy?
Yes, everything.
Leave to move on Wednesday. Wednesday you want?
Wednesday. Lord, may I in additional serve to the learned advocate who is appearing before the trial?
Mr. Mukherjee, I cannot say that because that's not the procedure.
Not the procedure.
So I cannot say that.
Very good.
Great. May I have this kind to revision applications with challenging minute and order passed?
What do you want?
My lord, it's the matter is supposed to appear tomorrow. I have been threatening that I will be removed from possession of business, hotel business. My lord,
it will appear tomorrow.
It will appear tomorrow if it could be, my lord, upgraded. Some preference can be given in the matter. My lord,
let it appear tomorrow thereafter. Yes.
My lord, it is with regard to item number 358 and 359 of your lordship says, my lord, we kindly recollect this matter was moved by Mr. Chatterjee and Mr. Banerjee. I am led by them. My lord, this is with regard to that restaurant, which is now a civil suit is pending.
No, what do you want?
My lord, listing because the on learned
court. It's appearing in the list you have said.
My lord, some precedents, I'll tell you lordship why. I'll tell you lordship why.
Difficult.
Today the matter is listed and the honorable and the learned court below, despite being informed that it is pending before your lordship, they're moving in hot haste to dispose of the injunction application. My lord, in that case, my revisional applications will become infructuous. This
nothing
is that
will
matter.
Happen. Nothing will happen if the main injunction is disposed of. Nothing will happen.
Your lordship was pleased to observe that your lordship will remand the matter for the jurisdictional thing, commercial.
Let it be done. Nothing will happen. If after that also it can be remanded.
Appearing in serial number 61 of the monthly list, your lordship, this is CO application challenging the impunity.
What do you want? What do you want?
I want upgradation.
Please come on Wednesday. Let me call. Yes, call the list.
16th is the date fixed for collecting blood samples in connection with the application for DNA test. 16 is the date fixed on the date of listed when the matter.
Any resolution taken today?
Action has been taken today, my lord.
My lord.
We are supposed not to attend this any of the courts, my lord, and we have already prayed before the Honorable Chief Justice that so that no adverse orders is passed.
All right, so
we are
if
not
none of you appear, I can rise.
Let the matters retain its own position so that it can be taken up tomorrow, madam.
Matter will retain its position. Notification.
So I am not mentioning. I am saying that. Let it retain its own.
If you do not appear, I can rise. If you remain present, I have to call the list.
The resolution has been passed. We were there, my lord.
Ask your members to abide by your resolution.
Probably they were
not there in the rules. So I am only saying that the item number 73, that custody matter, that your lordship was pleased to keep it today to retain its position, is gone down as item number 73. It can be taken up anytime tomorrow. Today will be a little difficult.
Mr. Banerjee, today, as you have heard, so tomorrow's matters will also come. So precedence giving is maybe a difficulty.
Let the matters retain its position, my lord, tomorrow, so that matters can be done.
It will appear.
Tomorrow's matters can be lower. Let today's matters be kept in.
I think that is because the matters which have been the date has been fixed tomorrow, that will come top. After that, this will retain its position. Because otherwise it will be a difficulty, because tomorrow's, if someone has mentioned, they will say because they have given the date by that. No serial number will be disturbed, but that matters will come top thereafter these matters. Yes, Mr. Chakraborty, you have taken a resolution.
No adverse order in absence of the party.
Nothing, there is something more. Matters to retain its position. Yes, what is the resolution? And members will be requested not to participate.
Not one. Part of the mention.
Mr. Chakraborty always.
Very well.
Oh, that is not participation. That is not participation.
Advocate, request to advocate.
I have no difficulty, Mr. Chakraborty, I tell you. I can proceed with the matter. I have no
We are
difficulty.
not asking my lord to proceed with the matter, but as your lordship pleases, my lord.
All right, what do you want?
This is already fixed at 3 p.m. It's running in the list as fixed at 3
Today?
No, it's not being 297, item 297. It is marked for 3 p.m. My lord. It's in the list for quite long. It's a custody matter. My lord is taking up the motions, then it is not being brought the court.
Mr. Chakraborty, what can be done before the
I'm not
vacation?
being to see my son. One day, 3 p.m. takes it up. Any day, my lord is taking up the motion, then is not getting exhausted. So my lord is not being able to reach to
That
that.
is the only
Only one day.
prior to vacation.
My lord is-
Motions have to be given.
This is also a motion. Custody matter. Court has said I have to go and see my son in court. Only for that. My lord has already passed order. Similar order will be asked.
So the difficulty is that some matters you are praying for upgradation.
But
Some
this is also upgraded by my lord.
Mr. Chakraborty, all motions.
Is-
Nothing is
not-
contested.
I'm not here to bargain.
Very matters for
I am not here to
contest.
bargain.
all motions.
My lord is taking up matter only 3 p.m. matter. This is the only perhaps which is not being reached because my lord is
Only
taking up-
one 3 p.m. matter.
maybe one. This is the one. Maybe one. Maybe two. এই কটা 3 p.m. আছে?
3 p.m. কটা আছে? একটাই আছে।
আমার তো any day at 3 p.m. Today it's not possible. Any day, whenever it commences to also any day at 3 p.m. My lord is taking up 4 p.m. Past any day, my
You are
lord.
saying one.
Only take. Or I have only one, bro.
You have
Take up
only
3.
one.
One day give 3
And
p.m.
few others you have 4.
Only
Few others you have 4
my
more.
lord is taking up 4 p.m. matter. Motions are lord 60-70 motions.
Mr. Chakraborty, I have no difficulty in taking up.
The
If I
custody
take from
matter-
3 p.m., 4 p.m., motions will not be touched. If all of you agree, I do not have any difficulty.
Don't
Then
say
don't
that,
say
bro.
motions are not being reached.
Don't say that. Not only if one day before vacation, my lord takes up this not because this is a
All right, I
custody
will
matter.
keep in mind.
My lord, non-custodial father, my lord, I can't see my son. At least before puja, I'm seeking some order so that I can take him out on one day in
I do
puja.
not know what will happen today. Today's all motions will
Yes,
get
that
stuck.
I understand. It will be piled up again. But we can
Please
consider this.
Consider the
Yes,
predicament
yes.
of the court.
We have
That's
one
the
man, my
only
lord has
difficulty.
100 things. One day, kindly consider this.
All
Just
right, I will consider that.
some, if my lord takes a marked any day, my lord takes up not only this.
I will consider that. Yes. Yes, what to do, Mr. Mahato?
We will not call for him to
Since
just-
well, power has already taken resolution,
Yes.
we have to abide by it.
All right. So, লিস্টটা একবার কল করে দিন। লিস্টটা
Item number 1 to 10. Item number 11 to 20.
11 to 18 ওরম ভাবে করছেন কেন? পরপর কল করে। হ্যাঁ। পরপর কল করে।
Item number 1. Item number 2. 3. Item number 4. Item number 5. 6. 7. 8. 9. 10. 11. 12. 13. 14. 15. 16. 17. 18. 19. 20. 21. 22. 23. 24. 25.
26, 27, 28, 29, 30, 31, 32,
Take your seat.
We can't leave your lordship alone. We have to, somebody has to be here, but as long as the
34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, 70, 71, 72, 73, 74, 75, 76, 77, 78, 79, 80, 81, 82, 83, 84, 85, 86, 87, 88, 89, 90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101, 102, 103, 104, 105, 106, 107, 108, 109, 110, 111, 112, 113, 114, 115, 116, 117, 118, 119, 120, 121, 122, 123, 124, 125, 126, 127, 128, 129, 130, 131, 132, 133, 134, 135, 136, 137, 138, 139, 140, 141, 142, 143, 144, 145, 146, 147, 148, 149, 150, 151, 152, 153, 154, 155, 156, 157, 158, 159, 160, 161, 162, 163, 164, 165, 166, 167, 168, 169, 170, 171, 172, 173, 174, 175, 176, 177, 178, 179, 180, 181, 182, 183, 184, 185, 186, 187, 188, 189, 190, 191, 192, 193, 194, 195, 196, 197, 198, 199, 200, 201, 202, 203, 204, 205, 206, 207, 208, 209, 210, 211, 212, 2013, 2014, 2015, 2016, 2017, 2018, 2019, 220, 221, 222, 223, 224, 225, 226, 227, 228, 229, 230, 231, 232, 233, 234, 235, 236, 237, 238, 239, 240, 241, 242, 243, 244, 245, 246, 247, 248, 249, 250, 251, 252, 253, 254, 255, 256, 257, 258, 259, 260, 261, 262, 263, 264, 265, 266, 267, 268, 269, 270, 271, 272, 273, 274, 275, 276, 277, 278, 279, 280, 281, 282, 283, 284, 285, 286, 287, 288, 289, 290, 291, 292, 293, 294, 295, 296, 297, 298, 299, 300, 301, 302, 303, 304, 305, 306, 307, 308, 309, 310, 311, 312, 313, 314, 315, 316, 317, 318, 319, 320, 321, 322, 323, 324, 325, 326, 327, 328, 329, 330, 331, 332, 333, 334, 335, 336, 337, 338, 339, 340, 341, 342, 43, 344, 345, 346, 347, 348, 349, 350, 350, 351, 352, 353, 354, 355, 356, 357, 358, 359, 360, 361, 362, 363, 364, 365, 366, 367, 368, 369, 370, 371, 372, 373, 374, 375, 376, 377, 378, 379, 380, 381, 382, 383, 384, 385, 386, 387, 388, 389, 390, 391, 392, 393, 394, 395, 396, 397, 398, 399, 400, 401, 402, 403, 404, 405, 406.
My lord, 406, my lord. My lord, I appear for the petitioner. My lord, the estate officer's hearing is, my lord, fixed today. My lord, on the last occasion, your lordship had directed, my lord, service on, my lord, the respondent, my lord, the opposite party. But, my lord, and, my lord, item number 69 is also my application connected to the same matter, my lord. If your lordship, my lord, so commences, my lord, I can, my lord, start the matter. And, my lord, if your lordship, my lord, it's a very, my lord, innocuous point, my lord, which is before your lordship, but I leave it to your lordship, my lord, whether your lordship will entertain me today or not.
It's up to you. It's your resolution. Why are you
Yes, my lord.
putting the on my shoulder? It's up to you. You are not a member of either of the associations.
I am a member of the bar
So
library
you have not
club.
taken a resolution.
I have taken a resolution
So
not to pass adverse order in
up to you.
absence of party.
It or not. Don't put it on the shoulder of the court. It's up to you.
My lord, 69, there is no, my lord, direction for, my lord, service on, my lord, the opposite party.
You are saying it's interrelated matter.
Yes, it is. It is.
So it's up to you.
But if you're,
You have
my lord,
taken a resolution. It's not no adverse order, not to pass any order. And there is a direction for service. Now it's up to you to abide your resolution or not.
my lord, your lordship can, my
Don't
lord,
put
take
it on
up,
the
my lord,
court.
and I will not never. My lord, if your lordship, my lord, so, my lord, commences that, my lord, can I, my lord, press, my lord, item number 69 before your lordship, my lord?
It's up to you. If you want to move, I will take care.
Yes, my lord. If your lordship, my lord, kindly, my lord, takes up, my lord, item number 69, my lord, in that event, my lord.
Yes, let me অন্য
through
ম্যাটার
the
গুলো
list.
কল করে দিন আর হয়ে গেছে সবকটা কল অলরাইট আইটেম নাম্বার
69, my lord.
ইয়েস
But item number 69, if your lordship, my lord, kindly takes, my lord, the order.
বোর্ডে 69 দিয়েছেন
That is why, my lord, I'm not, my lord, moving item number 406, but on item number 69. My lord, item number 69, if your lordship, my lord, kindly takes the order.
but you are saying it's a interrelated matter.
But I'll tell your lordship what has happened. So, my lord, initially, my lord, a suit was filed in respect of a public premises, where, my lord, I have been, my lord, enjoying an order of injunction to not to disturb my possession. Now, my lord, I was, my lord, a sitting occupant in, my lord, the public premises. There was a specific direction, my lord, against, my lord, my lord,
Sitting occupant meaning thereby you are not the original lessee.
I'm not the original lessee. What had happened is, my lord, the original lessee, my lord, against the original lessee, a proceedings for eviction was initiated.
Sitting occupant means you have exercised your right of first refusal.
I have, my lord, not exercised my right of, my lord, the first refusal. I have not
Why?
been. What I'll tell you, lordship, I'll tell you, lordship. My lord, what has happened is, my lord, there's a checkered history in this matter. What has really happened?
What is the order under challenge?
The order under challenge is very innocuous. The order under challenge is that there is a maintainability, my lord, application, which is, my lord,
Where is
pending
that
from the
order?
estate
Where is that order?
If your lordship kindly sees, my lord, I have order number 72 dated 11th of August 2025. Your lordship, that's the impugned order in item number 69. Your lordship will find that, my lord, what they have done is 2 applications were filed. And, my lord, these 2 applications had not been disposed of. Before, my lord, coming to the impugned order, if your lordship kindly takes the previous order, that is, my lord, order number 70, which is, my lord, at page, I'll tell you, lordship, my lord, page 115. Kindly, my lord, takes page 115, my lord, once. Very interesting, my lord. The last paragraph at page.
Give me a minute.
Very.
Yes.
Now, if your lordship kindly takes page 115 once, which is, my lord, the prior order. Kindly sees page 115, page 115.
Yes.
Your lordship kindly takes, my lord, the last paragraph at page 115. Lord, heard the submissions and considered the matter. I am consciously of the view that the PP Act operates in a field where the Act itself specifically provided the jurisdiction of this forum, adjudicating authority under the Act. And any question about the pendency, maintainability of the proceedings is not sustainable without any appropriate order. Kindly marks this. Any question about the pendency and maintainability of the proceedings is not sustainable without any appropriate order, restraining the proceedings, etc., from any competent court of law. Therefore, the opposite party number 2 is directed to file show cause reply to the show cause notice dated such and such, and my lord kindly considers this. SMPK, which is my lord the Port Trust, is at liberty to file their comments, if any, with regard to OP number 2's application dated 30th June 2025.
OP number 2 is you.
Yes. So, my lord,
what was your application?
my application was, my lord, challenging the maintainability of the proceedings because,
Yes.
my lord, if your lordship
So that
sees-
was fixed for hearing on 28th of July 2025.
my lord, 28th of July 2025 when it was fixed. My lord, kindly sees, my lord, now, my lord, the impugned order, which says, strangely now, which says that it has been disposed of and it has been decided.
Where it has been said?
If your lordship kindly takes, my lord, may I, my lord, read, my lord, the last paragraph of the, my lord, the impugned order, which is at, my lord, the first page, last paragraph.
Yes.
It is pertinent to mention in this context that in terms of the order of the City
It is,
Civil Court dated 20th of February 2024, my lord, I am reading, my lord, the first page, the last paragraph.
It is pertinent, yes.
It is pertinent. It is pertinent to mention in this context that in terms of the order of the learned City Civil Court dated 20th of February 2024, the instant proceedings has been remanded back to this forum from the stage of issuing notice under Section 4 of the PP Act. And accordingly, the matter was taken up on 7th of April 2025. As per the order of 7th of
So
April,
where is the order dated 28th of July? Please show me the order dated 28th of July.
page 117, my lord. That's at page 117. My lord, may I, my lord, go through this and thereafter show your lordship?
Show me first
Very well.
28th of
117.
July.
Very well. Kindly seize, my lord. It was not, my lord, considered. At page 117, those applications were not heard and considered. No reply was filed by SMPK with regard to the applications. All that I am before your lordship for is, my lord, let the maintainability applications be heard. It was never disposed of.
Now, what is CO 2658?
My lord, that is item number 406.
That is item number 406.
Yes.
So you have paid for an adjournment on that ground, pendency.
Pendency of the, my lord,
So
civil division
on that
application.
ground, you have not pressed your application for maintainability. What
we
can
have,
be done?
What we have done is kindly seize now, my lord, the impugned order, which will, my lord, take
So by
precedence.
this, as there is no stay to proceed, I am not
Kindly seize, my lord, the impugned order.
with the direction. So you are directed to file reply to the show cause. So,
done
on
that.
11th of August, did you file the reply
Yes,
to the show
we have
cause?
already filed reply to the show cause. Everything is ready, but, my lord, we have not been given an opportunity to place our, my lord, maintainability application, despite, my lord, giving directions for, my lord, filing comments. Lordship kindly sees, my lord. I'm reading, my lord, the paragraph, last paragraph of the first page of the impugned order.
What is under challenge in CO 2658?
My lord, order number, my lord, 70. That's at page 115.
Oh, this is under challenge.
This is under challenge that you have, in a preconceived mind, determined my maintainability application and despite thereof given direction for affidavits to be filed by the Kolkata Port Trust. Surprisingly now, in the impugned order before your lordship in item number 69, my lord, what they have done is they have said that they have already decided my application, despite a specific direction for giving comments. Absolutely contrary to both the records. They being a statutory authority, they cannot, my lord, shun me down, my lord, in complete violation, my lord, of the justice, principles of natural justice. And all that I'm asking is, my lord, that the maintainability application be heard. That's all. Let them reject it, but at least hear it out. I filed my reply to the show cause notice without prejudice to my rights to the applications. Because now, my lord, your lordship knows there's a Supreme Court judgment, my lord, which says that if, my lord, there is an order, a suit which is pending,
Applications which you filed on 11th of August 2025.
my lord, these two applications, I'll tell your lordship, my lord. Page 119, my lord, and 135, 134.
119.
Yes.
What is the prayer in this application? 119. Prayer is at
Recalling of, my lord, the last order, my lord.
recalling of 28th of July.
28th of July.
Done in 28th of July. You have prayed for recalling.
My lord, I have prayed
You have
for,
only been directed to file the recalling, to reply to the show cause,
Yes, my lord,
and you have prayed for recalling of that order.
yes, I'll tell you, lordship, why. Because, my lord, without hearing my maintainability application, the very fact that they have given direction
That
to
is a
filing
different
reply.
thing altogether.
This
By
is why I have filed.
28th of July, you have been directed to file your reply to the show cause.
Yes.
So that was only done, and a date was fixed for filing reply to the show cause, and we have paid for recalling of that.
I have prayed for
So this
recalling.
is that you are trying to delay the
But
proceedings.
I have, my lord, I'll tell you, lordship, very frankly.
And what is the other application?
The other application is at, my lord, page 134.
Yes.
But I have sought for, my lord, documents from, my lord, the SMPK to say that on the basis of what are they asking for eviction of mine? When there's a specific order of, my lord, this honorable court in a civil divisional application to consider the matter afresh, give me a fresh notice. A section 9 appeal was preferred. In a section 9 appeal also, it was
Where is
given.
the prayer in at page 134 application? Where is
My lord,
the prayer?
147, my lord, 147. This has also not been done, disposed of without giving me a hearing. Interestingly, my lord, what was the remand order? Kindly seized the remand order. If your lordship kindly takes page 66, my lord, once. Kindly takes page 66.
No,
once.
no, I will come to that. I am at page 147. Let me consider this one.
Yes, my lord.
What is your prayer B in page 147?
My lord, prayer B is, my lord, to give me time to consider and file a
To file a
supplementary.
supplementary reply to the show cause. Why?
Because I'll tell you, lordship, my lord,
So
there
you
are several.
wait for time, extension of time, then also the correct reply to the show cause notice was not filed. Then you have filed one reply, you want a supplementary to be filed.
Yes, I'll tell you,
The
lordship.
way you are proceeding.
But I'll tell you, lordship, my lord, kindly, my lord, do not takes me amiss with regard
And
to,
to
my lord,
defer the hearing of the instant proceedings at least 4 weeks till the disclosure.
yes. Because, my lord, until and
Also,
unless I
you
get
also did not want your maintainability application to be decided. You wanted the entire proceedings
the
to be
civil
deferred.
divisional application was pending, my lord, it's still pending.
You did not want, your prayer was not that to fix a
How
date for
can I pray, my lord, before the Honorable High Court as well as before the, my lord, learned estate officer, my lord?
that is
I could not have, my lord, asked for that.
that
prayer,
is
my lord.
so. So unless you
not have
move
asked for that prayer.
406, so how can this be taken up? Because this is related to 406,
But I'll
and
tell
your
you, lord,
ground is of that.
kindly, my lord, bears with me for one more minute, my lord. My lord, kindly takes page 66. My lord, this was the order in remand in a section 9 of the Public Premises Act 1971 appeal. Page 66 of, my lord, the application.
Yes.
And, my lord, kindly straight away comes to, my lord, page 87. What was the direction asked? Today, my lord, the statutory authority cannot, my lord, go beyond, my lord, the direction given by the, my lord, competent court. Kindly see, my lord, paragraph 47, page 87.
Yes.
At, my lord, page 87. Since the eviction proceeding was terminated under section 5 of the PP Act, as soon as the eviction order dated 27th May 2002 was passed, the estate officer has no jurisdiction to reopen and continue the said proceeding. If your lordship sees, my lord, the proceeding which has been continuing is 390 of, my lord, 2000, my lord, of 390 of 2000, which is their same proceeding which they are continuing. The ESTA has no jurisdiction to reopen and continue the said proceeding at the instance of the respondent number 1, who has already been evicted, and the estate officer and his successors in office have exercised their jurisdiction arbitrarily and in derogation of the statutory powers conferred on them, where the Honorable Court has been pleased to direct the estate office to hear the matter afresh
in CO number such and such. It shall not be out of place to mention that the estate officer is not empowered to dispense with the statutory formalities for drawing an eviction proceeding under the provisions of the PP Act. So specific case made out that there should be a separate eviction proceedings against me. Now kindly seize my lord all the orders, including the impugned order, passed in the old proceeding of 390 of 2000 against the erstwhile tenant or the erstwhile lessee. How can this proceeding continue? And there is a suit pending, and the Honorable Supreme Court has said when there is a suit pending and there is an order of injunction, then you cannot be termed as an unauthorized occupant. These are the points of maintainability I have taken in my application. Without considering that, how can the estate officer assume jurisdiction and go
What
ahead?
is your application for maintainability?
But I'll tell you, Lordship. Page 98.
98.
Yes. So my prayer today before your Lordship is very innocuous, my lord. Let them, my lord, please consider my maintainability application. I'm not my lord, asking your Lordship to, my lord, decide the maintainability application. Let the estate officer at least continue. And my lord, prior to the maintainability application, kindly see, my lord, page 97. This is their eviction petition, which they have filed. Page 97, a letter, not even an affirmation.
Please give me a minute.
Very good. The entire facts have been, my lord, narrated. My lord, starting from, my lord, passing of, my lord, the order on at paragraph 5, from interfering with the peaceful possession and enjoyment of the suit premises. Thereafter, my lord, they filed an order 7 Rule 11, which was rejected. Filed an order 39 Rule 4, which was rejected. Modified to the extent of deposition of money, which we have deposited pursuant to the order. Order 39 Rule 4. Then kindly see, my lord, paragraph 11. And my lord, paragraph 13 is what I am pressing for, without even issuing a notice.
What is the next date fixed before the estate officer?
Today, my lord, today. That's the urgency. Otherwise, my lord, my this sign of desperation would not have been there. My lord, I never do this, my lord, but it's been fixed today. সুপ্রিম কোর্টে জাজমেন্টটা দেখা হচ্ছে, যেখানে বলেছে যে আনঅথরাইজড অকুপেন্ট হবে না।
Item number 406 টা একটু দিন তো। Yes, Mr. Nag, you are appearing in this matter. This is a port trust matter.
দাঁড়িয়েও না।
That is 406. The other matter is 406.
406 matter.
406.
That's not challenging order number 70, by which, my lord, in a preconceived mind, they said that maintainability application is not maintainable, but despite that, gave direction for affidavits in the maintainability application. And now, my lord, in the impugned order, they say that I've already heard the maintainability application and it has been decided by the order of 38th, that order number 70. In fact, my lord, there is a, my lord, Supreme Court judgment which says, my lord, that when a suit is pending and there's an order of injunction, if I may, my lord, only be permitted to rely on this also, my lord, paragraph 18 and 19 to Devin to kindly. Brother. 18 and 19, my lord, paragraphs. There every attempt being negated in the suit. Because there was a specific order to that extent who heard the matter afresh.
No, you are not an LOT pursuant to an allotment letter.
No, not an LOT.
Paragraph 18 says so, proceeds on that basis.
But you know,
paragraph 18 of the judgment proceeds on that basis.
yes,
Sitting occupant cannot come and say that I have been made an allotment.
interestingly, my lord, over here I am in a better
You have the
position.
circular of sitting occupants regularization.
I know, my lord. I have a better position. I'll tell your lordship why. What had happened was, my lord, the Kolkata
Show
port
me
trust
that
but
circular
I'll
of
tell you,
sitting
lordship, the orders where, my lord, we have been given a better position than the allotee. What they have said is, my lord,
You have a better position than the allotment.
allotee. I'll tell you, lordship, why. My lord, what had happened is, my lord, initially, my lord, when, my lord, the proceedings were initiated against, my lord, my lessee, or, my lord, the lessee under the Kolkata Port Trust, what they did was, my lord, they said that very well, you are counting, you're being evicted, but with regard to the sitting occupant, I'll consider, you pay the arrear dues, I'll consider that. So I paid I made a demand draft. I was out of pocket of that money. I came up with the entire arrear dues. I paid that amount. Thereafter, they said that no, you do not pay me X amount. You increase that and you increase that and you pay me this
You have
amount.
filed a suit.
I have filed a suit in respect of the specific performance with regard to that.
There is an
See,
injunction.
and there's an injunction.
Where is the order of injunction?
Very good. I'll give the order of injunction. So, my lord, a specific, my lord, case made out by, my lord, the
Please
post
show me the order of injunction.
My lord, if your lordship kindly takes page 63.
Yes.
This has been, my lord, confirmed and made absolutely the disposal of the suit. At, my lord, page 63 at 64, my lord, if your lordship kindly takes.
This order of injunction is still subsisting.
Till, my lord, subsisting and, my lord, till disposal of the suit. Order 711 filed, order 39 rule 4 filed.
What is
Not
the stage
initiated.
of that suit?
My lord, evidence stage. Evidence stage.
Evidence stage.
Almost on the verge of, my lord, starting.
Ashu.
My lord, a humble request, my lord. Yesterday we lost Jayanto Banerjee, our ex-president. My lord, today we have resolved a resolution to request your lordship not to pass any order in absence of any of the parties.
Entire list has been
Finished.
after his
And
mentioning.
there is a very specific request in the resolution to our fraternity members not
Please
to
tell
honor
him.
that resolution.
Please tell him.
Rest, my lord, we can't.
Please tell him. After the entire list was,
Lordship,
he came and mentioned this
I
matter.
can't restrain in my members. I can't. It's a request.
What can I do if your member, one of your member moves this matter? What can he wanted to put that on the shoulder of the court? He said, yes, it's your lordship. Once I said, no, it's your decision. You have taken a resolution. It's after all you whether to abide or not. He said, I have urgency. Then this is item number 62. After the entire list has been called, I've taken it. And I will also record that your member do not want to abide by your resolution. The entire list has been called. No one moved, but he mentioned this matter. Ashwin.
Just mention after lordship.
Vice President is here.
Already mentioned when I'm suffering an injury mode, and I will just mention.
Vice President is here. You have seen just now, he has requested you. He has requested all your members.
Not for today, my lord. But it was fixed at.
Mentioning is not part of a participating in a proceeding.
Yes, my lord, I am not going to do, but for any day fixation of that. After lordship dictates the order, I will just mention it.
Ashwin.
So,
It's your resolution. If you want to move,
My lord, I had, my lord, the desperation was there, my lord.
yes, Mr. Bhattacharya.
Who is here? Item number 408, we are suffering an interim order that too without condition. He was about to give reply for 15 minutes, any day convenient to your lord. And I leave it to the and lord. Order record করে দিতে
হ্যাঁ শুধু এটা না what is the item number?
Last
408. You are not there, Mr. Bhattacharya, when the matter was called on.
Huh?
You are not there when it
4 p.m. is not here.
could reach prior to 4 p.m. Now it's also not 4 p.m. Why have you come now?
No, I was called by my partner in crime. I was called by my partner in crime. But never mentioned without notice. আমাকে নোটিশ দিয়ে কি হবে মিস্টার দাস?
No, what do you want?
Without any condition. Well, 40 crores due of port trust. Well, that is why I am compelled to mention
Substance
any day. Well, lordship fixed for 15. Well, it may be 400 crores also. 4 p.m. fixed 400 crores. Lordship hard it. Extensive. Kindly, my lord, takes up the map. Takes up the matter on any day.
Mr. Bhattacharya, Mr. Nag, it's difficult to fix a date now because today's motions,
No problems.
today's motions, no matter. Tomorrow's and it's
I have
hardly 2 or 3 weeks. We do not know.
On the reopening
10,
day.
12 days only.
On the reopening day.
No, may not be on the reopening. I will try and take it up, but
My advocate on record will suffer consequence.
But
Lordship knows, Mallet. Well, I not have mentioned that. Well,
I know that, but please consider 2 p.m. It's difficult, Mr. Nag. Then motions will not be taken up. I have no difficulty personally. I tell you, it's for you. If you say yes, I cannot specify only one matter. I cannot specify only one matter. Many matters are fixed on 3 p.m. Mr. Chakraborty today mentioned for 3 p.m. 3 p.m. there are 5 matters, so I cannot discriminate. All those matters are to be taken up. Then motions will not be taken up. For personally, taking I have no difficulty. I can take it up any matters starting from.
On the issue of maintainability, we have concluded argument. He is just.
Yes, Mr. Bhattacharya, how much time he will take?
Hardly half an hour.
Half an hour? Why?
Maximum.
Why?
Outside limit is half an hour. At best 15 minutes.
Reply.
Well, at best 15 minutes. I am saying.
All right, let me see this week.
Well, apart from 10th, 10th Justice Ghosh has fixed a matter. In any day, apart from 10th.
Bhattacharya, busy lawyers, senior lawyers will have many matters before different courts. Busy lawyers, senior advocates will have many matters before different courts.
Well, in Bengali, they are the same.
Know how to adjust. Matters different courts.
We have not learnt, Milord, from so busy lawyers who have been elevated, Milord, that this much. Milord, we have not learned that. Well, I know, Milord, how busy your lordship was when on this side. So kindly do not force me to open my mouth.
As busy
kindly do not force me to open my mouth. I have got nothing to lose, nothing to gain, Milord. Kindly do not force me to open my mouth, Milord, please. Milord, kindly keeps it any day convenient to your lordship, Milord, apart from 10th.
Accepting 10th.
Any day apart from
Accepting 10th. All right, let me see how far I can proceed on 9th and 10th. Mr. Nag, you renew your prayer on 11th because 10th he has also difficult because I do not know how far I can proceed. Motions have to be given some precedence.
any day 4:30 lordship fix. Or
Oh, 11th happen because I have a division bench on 11th.
Next week, subject to your lordship's convenience, 15th or 16th.
15th, 16th किया तो 15th That week, 4 p.m. is fixed. 17th ফাঁকা আছে। 17th 4 p.m. Please, Mr. Bhattacharya, try to be brief. And if you want, both of you can come ready with the written notes.
Very well.
Yes, sir.
But it should be brief.
Just 2 pages.
Mr. Bhattacharya, it should not be as bulky as your petition.
Very well.
Written notes should not be bulky as your petition.
Online থাকিস
এরকম করিস না, please এরকম করিস না। তোমারটাকে তুমি তোমারটা আমি থাকবো না, আমি বলছি।
Then it's difficult.
19th notification.
19th, 4 p.m. That's a Friday.
even if it is a Friday, Millard, we'll do it. Irrespective, let it be at 3:30.
3:30
We'll do it at Millard, whatever time. Even if it is 5 o'clock, we'll do it. 19th.
The 19th করে রাখুন, 4 p.m. করে রাখুন. It is the 3:30.
One line. No. Consequences will follow.
Mr. Bhattacharya, you are not there. Mr. Nag was there. The vice president came.
No,
And the assistant secretary also came.
I know. Millard, call
What I do not have any
I have no problem. I have no. I am not even sitting anywhere. So, Millard, I don't.
Mr. Nag is sitting in Ballet.
He is also sitting, perhaps.
Library club has not taken any
Yes,
resolution.
Has taken
The cause of conscience is not there in the library club justice. Millard, I do not have a conscience. My conscience pricks.
clear.
Kindly take. Kindly passes an order.
Question is different. I say, well, I am not doing any matter, just to mention. Fix for easy.
See, both of you do not have any problem. You can move it today also. Why?
I just go through flip through the pages once. Well, at 2 o'clock. Today, 2 o'clock, I have no problem.
Pages? What pages? What pages? It's in your
19. Kindly keeps it on 19.
Or 19th order.
Well, at item 31, my lord. Order.
at an order record. What is your
Sorry, 408.
at the order?
Extremely good.
One short matter 31, Mallet. Today is fixed as a citizen. Very small matter, Mallet. Just one line order is enough. What happens? I'm
Actually,
telling
don't put the court in
because
place.
no caveat is there. I'm alone.
Item number?
31.
Where were you when the entire?
So, Mallet, I'm hesitating to appear. Mallet, then because of the resolution, I thought.
How you are not hesitating?
No, that resolution was appeared to me.
Resolution?
Give it to us by the only one person, Porido Sinha, it was then clarified. I'm hesitating because of that reason.
Item number?
31.
31, yes. What is this matter?
Malad, what happens, Malad? A receiver was appointed by the City Civil Court 11th bench.
Got the petitioner, Mr. Raichodhi.
So what, Malad? I'm not asking for anything, Malad. Not favorable. If I lost, I lost. I no matter. If I lost, I lost. No matter. Malad, receiver was appointed because urgency is that matter. There is a locker. There is ornaments, puja ornaments, Malad. My family puja. That is the oldest Durga Puja in Calcutta. Malad, what happens? The receiver appointed by the court to go there and
Item number 31, 30.
Well, kindly come to
What's
first.
the order you are challenging?
Yes, and that is the impugned order. Prior to that, I am kindly come to page 16, my lord, once.
1/6.
1/6. In the middle portion of the order, all sides have submitted fairly. My lord, got it?
Yes, yes.
That a receiver should be appointed to solve the problem of the bank locker, as there are many technical issues, oblique procedure.
So
Considering
receiver was appointed.
then receiver appointed.
Yes.
Receiver and branch manager was permitted to go inside the locker room. Then, my lord, I filed a modification application there
Of
that-
this.
of this application.
Yes.
Because after this order,
Now what happened to that?
after this order, the bank said the locker should be break open. So 2% to be there from the break open agency. Then 2 persons of the bank witness to be present. So 2 to 4 plus 2 other person appointed by the court, 6 persons. Then I prayed, why then, my lord, the plaintiff, myself, and the defendant should not be appeared.
Should not.
Should not be entered into the locker room.
Should be allowed to enter.
Should be allowed.
You are the defendant.
And the plaintiff.
And the defendant also you want them to.
I prayed, both of them, because 2 brothers. The court said the defendant should appear, plaintiff should not appear, rejected my petition and said, my lord, I have to pay 50% of the locker breaking cost. That is my subject matter of challenge.
Where is that?
That is, my lord, in page 32. My lord, kindly see the page, so the following persons. Page 32, so the following person starts.
Who is appearing for the defendant number 1 and 2?
Defendant number 1 and 2, my Simoy Banerjee was at.
So you have to serve the defendant number
But because
1.
no caveat was there.
No. Now you have to serve because
Well,
this order
just one
can
line,
be-
kindly see. So the following person, namely the receiver, branch manager, and then, my lord, learned advocate defendant 1, 2 has submitted that the estimation cost is 10,000 required to break open the locker. Defendant number 3 and the plaintiff shall pay the cost equal amount each to the bank in 2 days. Send a copy of this order to the receiver, namely such and such. And then, my lord, he rejected my application.
Any date has been mentioned for this?
Today, my lord, it's fixed at 2 p.m.
For breaking open the locker?
No, for the receiver's report. Receiver cannot go.
Yes, who are you? You are not appearing in this matter. Where is your application?
This is my modification application, my lord, that is in page, my lord, 10.
Nominee is the defendant number 3.
Yes.
What is the suit for?
The suit for, my lord, what happens? My mother died in 2024. Now
You have brothers and sisters.
only one brother.
And who are the other defendants?
Other defendant 1 and 2 is bank, and 3 is my brother.
Oh, so 2 sons.
2 sons. My lord, because the locker's key was lost, he requested the bank to break open the locker. So I said, I am also
These
one of the.
articles are of the mother.
Yes, the mother. Then, my lord, what happens? The bank said, if you want to take part, you have to file a case. I filed this case. Then receiver was appointed on 7/8/2025. Then I filed a modification application saying that
is the modification application.
Yes, modification application is, my lord, in page 11. This is my modification application. In paragraph 11, I said, hence at the time of break open of the locker for inventory, the following persons required to be present: the receiver, the branch manager, the witness of the branch, the witness of the bank, representative of breaking agency, representative of the breaking agency 2, Goldsmith.
No, so you wanted so many persons to appear.
Yes, my lord. Nothing more I am asking. And in the first appointment of.
Not only that, apart from them, only the plaintiff and the defendant number 3. So breaking agency will be there.
Yes, receiver will be there, branch manager will be there, 2 witness of the bank will be there.
No, witness of the branch and witness of the bank, where is the difference?
No difference. No
So
difference.
why have you prayed for both?
No, they say it. They say they will come.
Oh, they said.
Bank said. Now the question is, in the first order, appointment of receiver, he didn't allow myself and my brother. Now in the modification order, while I'm saying 6 other persons were going inside the locker room, why not my brother and myself will allow? He then said, you will not allow, you pay 50%, your brother will. This is the only person, nothing more I'm asking. Today at 2 p.m. the matter was fixed.
There is one technical problem because order appointing receiver is an appellable order under order 43.
No, what I'm saying, my lord.
Modification, modification, if it is rejected, there is nothing called modification. So it has to be under order 47. Whatever name called, if the modification is rejected, then you have to challenge the parent order.
Kindly see.
You have to challenge the parent order.
Kindly see what is the order.
Parent order is an appellable order.
Kindly see what is the he's saying. In page 32, learned advocate for the defendant number 1, 2 bank submitted that the estimation cost is 10,000.
So it has been modified.
It's
According
modified.
to you, it has been modified in part.
In part. Defendant number 3, plaintiff shall pay the cost of the amount. Then Malad is still pending matter.
No, Goldsmith shall not be present inside at that point.
Said now. So 6% is automatic.
So,
2 witness, 2 breaking agency
shall be allowed.
manager, 6%
The locker shall be allowed. Branch manager is permitted to allow 2 witness of the bank and as may require. The petitioner is aggrieved
expeditious disposal. Kindly sees the number of adjournments which the petitioner has suffered. Kindly sees once the number of adjournments which.
Item number?
41, Your Lordship. Oh, this is just a list of dates showing the adjournments. Your Lordship sees once.
41.
5-6 consecutive adjournments allowed.
You being the members, you are not abiding.
Your Lordship, I am a member of the library and
Library has not taken any resolution, not accepted, not adopted the resolution of the bar association.
So library has taken a resolution.
What are you saying?
They are the first one to take the resolution. Association has taken later.
He was also a member of your library.
Your Lordship, I completely appreciate, but
Yes. Yes. What is the suit for?
matrimonial suit.
Who are you?
I am the plaintiff, Your Lordship.
Plaintiff, I understand. Husband or wife?
Husband.
Any proceedings for alimony?
Your Lordship, that there is another miss case, which my yes, Your Lordship.
Is it pending or disposed? Miss cases for alimony?
Yes, Your Lordship. Interim maintenance.
Is it pending or disposed of?
Pending, Your Lordship.
আসুন একদম উপরে করে দেবেন But miscellaneous case has to be disposed of first.
Yes, your lordship.
That is, I have directed that.
Item 76 of your lordship's monthly list, my lord. The other side is not on caveat. What has happened?
Monthly list.
Monthly list, my lord.
Lordship, item
But
number 72 of
well,
the
kindly, the urgency is that P1000 was the initial alimony pendentility and application for enhancement was done, which has been rejected. That is the difficulty, my lord. I am the
Item number 76.
76 my lord of the monthly list.
The two matters, my lord. I also, my lord, bit hard pressed. My lord, item number, all are.
Don't have to stay hard pressed on that. If you want to move, you are free to move.
451, one is for expeditious hearing before the DRT, my lord.
If you want to move, please supply the numbers so that they can take out the file.
451 of the-
Please put it in a piece of paper. Please, একটা সাদা কাগজ দিয়ে দিন তো। একটা সাদা কাগজ দিয়ে দিন। Please mention the item number, monthly list, daily list, but provided there is no caveat, you can put it the item numbers. Provided there is no caveat. Please, all of you put it in that paper. All of you who want to move, please put it in this paper. Your number. Monthly item number 76. What is the cost title?
Kalpana Shaha versus Suprabhat Shah.
All right.
And
What is the order under challenge?
this is the last in the certified copy is the order date 4th September 2024. By
Who are you?
the respondent wife in a matrimonial suit, my lord.
Enhancement of alimony rejected.
My lord.
What is the stage of the matrimonial suit?
My lord.
Sure, sir.
For 20.
Sure, sir.
My lord, initially there was an interim order of maintenance of 3,000. That is at page 23, my lord.
Yes.
That is the order is of 7th September 2015.
Yes.
And thereafter,
What was the income of the husband at that point of time?
that point of time, my lord, will kindly come to page 23, the third paragraph. Petitioner files his petition claims for alimony from opposite party at the rate of 20.
No, where is the finding with regard to the income?
Uh,
Oh, 18,000 per month.
My lord, at present he draws 24, my lord. 1, 2, 3, 4, 5, 6. Seventh line, my lord. Your OP husband is an employee of Brahmo Balika Shikkhalaya, and at present he draws 17,865 towards salary.
17,865. Yes. Now, what is his income now?
What he alleges that his income is only 18,556. That is not by way of an affidavit. He has not disclosed that by way of an affidavit.
What is your statement that is his income? He is now still in service.
Still in service.
Still in service.
Still in service.
Where have you said that? What is your age? Your age is 65.
My
What is
age
the age of your husband?
my lord,
You are saying that he is still in service.
But I'm sorry. He says that he has a pension of 18,500.
So he has retired.
My lord.
Pension of
18,556.
Then
That is his
income has got
statement. But that is not an affidavit. That is a bold statement from
this
his
application under
Lord, I'm appearing for the petitioner. This was a matter.
72 supplementary or monthly?
Daily list, your lordship.
Daily. কিন্তু আপনার monthly করা আছে। Please put it in that piece of paper. ওই কাগজটা দিয়ে দিন। কাগজটা দিয়ে দিন।
Praying for expeditious disposal. Your lordship had on the of our partition injunction suit on the last occasion, lordship had directed the petitioner to find out who is the advocate because the matter concerned to Baripur court. Your lordship, for the petitioner, the plaintiff, it is Ajit Kumar Singh, advocate, and for the defendant is Sam Chaudhuri, your lordship. Lordship is pending before the learned second civil judge senior division at Baripur, title suit number being.
What is the stage of the suit?
Lordship, for filing of WS and W, your lordship, the next date being 26th of November.
Filing of
written statement.
And is the service upon dependent numbers 1 and 4 to 6 complete?
Complete. SRAD is complete, lordship. After that, your lordship, and
SRAD means complete. What is the meaning of SRAD?
Service return, your lordship.
So this is the order of 8th of April 2024. You have not annexed any subsequent order to show that it has been served.
Lordship, thereafter on the 6th of August, your lordship, defendants appeared and they prayed for time for filing written.
Defendants. Which defendants? Show me that the dependent numbers 1, 4, 5 and 6 appeared.
Lordship, 6th of August was fixed for filing of WSW by defendant number 1, 4 to 6 and SR on rest, your lordship.
Yes,
as per
SR on rest.
Lordship, as per order dated 8th of April.
Yes, so only 1, 4 to 6, 4, 5 and 6 appeared. Others have not appeared. Ashun, this application under Article 2.
Monthly title number 476.
Lordship, in this matter, I am appearing for the revisionist.
Yes.
It is a suit for eviction and recovery. The suit.
What is the order under challenge?
The order under challenge is an order whereby the trial court has allowed the defendant to file their written statement and has accepted their show cause at the stage of argument.
Show cause for what?
For filing show cause for filing the written statement.
All right, please give me a minute.
Lordship.
What is the suit for?
Suit is for eviction and recovery of possession.
Why do you want a walkover?
Lordship, it is not a walkover. Lordship will kindly see that Lordship will kindly
It triumphantly appears to this court
Petitioner is agreed by the order of enforcement of the ex parte order of injunction passed in miscellaneous appeal. Well,
enforcement of the enforcement by police help.
police help, ex parte order of injunction. Well, in 2012, my lord, I filed a suit challenging the deed that is thicker tenanted property. I am the thicker tenant. 2012, they are contesting this suit by filing written statement. I have annexed that. Suppressing everything, my lord, they filed a regular suit for injunction, but injunction was refused by the trial court. But against that order, refusal order, they preferred miscellaneous appeal and got an ex parte order of injunction. Thereafter, two applications are filed. One, order 13 rule 7, and another is 151 for enforcement of the injunction order. 13 rule 7 rejected by the Learned Court of Appeal below, but allowed this section 151 application.
Where is the order of status quo?
Well, I have not annexed, but they have mentioned this order in their application.
You have not annexed. Why? Where is the order of status quo?
Kindly turn to Annexure 1, page 92. That is their application, paragraph 1, page 92.
Page 92.
24 June 2004, against the respondent by of status quo in respect of position and nature and character of the suit premises. I am the thicker tenant. I am paying the ground rent. A thicker tenant to property transfer. I have challenged the deeds in my suit in 2012. The thicker tenanted property cannot be transferred in view of section 6 and 7 of the Thicker Tenancy Act. That suit is pending.
So, the addendum prayer for injunction was rejected.
Was refused by the trial court.
Yes, thereafter they preferred an appeal.
Miscellaneous appeal.
In the appellate court, an addendum order of injunction was passed.
But I am the thicker tenant.
The
Release charge number 177.
Yes.
For a section 17 appeal before the DRT.
For section 17 before the DRT.
Yes. Now, my lord, surface. Now, my lord, I know, my lord, appeal court is there. No, well,
not appeal court, appellate tribunal.
Appellate tribunal. Now, my lord, difficulty is, my lord, in the section 17 application, we have specifically pleaded. Lord, you kindly see one document. My lord, the amount was given to, my lord, the private opposite party for supplying of certain machines and equipments. This amount was given directly to them so that the machines can be supplied to me. Now, my lord, a skeleton machines were supplied, my lord, bulk portion of the machines were not supplied. Now, Lord, kindly come to page 50.
Those are on merits.
I'm not married. I'm not that. Okay. Why, my lord, I'm saying page 53.
Yes.
That's a part of, my lord, my 17 application.
No, 17, what was done? What was the prayer? Where is the order passed under section 17?
Order not passed. Number direction was given to file reply to the section 17 application.
Yes.
As on date, no reply has been filed. What they have done, my lord, they have approached, my lord, the chief Metropolitan Judicial Magistrate for taking possession of the property. There, my lord, I filed an application for stay. Look, they are going to, they are on, in one hand, they are not giving any reply, without dealing this specific document. Now they are, my lord, bypassing this tribunal and taking possession. Now, this tribunal, while dealing with the application for stay, practically did not deal my application for stay. Before that, Lord, kindly come to page 53 once. Why these documents are required to be dealt with by the bank? Page 53. Have you, Lord, got?
53. Yes.
53. These are later issued by, my lord, the private opposite party, the person to whom, my lord, the amount was given. Number of page 54. Next page.
This is BB Engineering to the bank.
To the bank. Now, my lord, kindly come to page 54.
Yes.
They have admitted, my lord, we could not supply the material. In the facts and circumstances as stated above, I do have a request you to kindly intimate me whether I shall refund back non-supplying machinery's value. That is the price of the said non-supplying machinery to the said Bonshi Mohan Das, proprietor Ms. Daskatai Center, or not, on his unwillingness to purchase the same from me. Now, Lord, kindly come to page 56. Bank in reply, my lord, had written, my lord, to the we are in receipt of your undersigned letter such as we have visited the shop such and such.
But where is the order passed by the tribunal?
Tribunal.
So
now, my lord,
why can I not approach before the appellate tribunal?
My lord, it was not decided on merit. Lord, can you see the tenor of
any order it says?
Yes,
can you not take that point before the appellate
yes,
tribunal?
My lord, kindly come to, my lord, the order dated, which is under challenge, page 28 February. Tribunal said this tribunal did not understand tenor of the application. Lord, kindly see, my lord,
that is a different thing.
Lord, kindly see, my lord,
nothing approach the appellate tribunal. Appellate tribunal.
My lord, it is not an appellate order, my lord. Kindly see, my lord.
Why?
Lord,
any order,
any order, my lord, see, my lord, but not on this, my lord, not decided on merit. Lord, kindly see.
Where it says that it's decided on merit. All points are.
Yes, yes, my lord. Any order.
Are you shying away from going to the appellate?
No, my lord. What is the difficulty, my lord? At the point of time, my lord, Chief Judicial Magistrate, my lord, about to, my lord, pass an order for taking possession.
You can approach the appellate tribunal and pay for stay. Where is the difficulty?
My lord, kindly see, my lord, order, my lord, on once, my lord. Why, whether, my lord,
page,
my lord, it is a certificate copy, my lord. Pay, order it, my lord. Last page, my lord. Last annexure.
Oh, yes.
28 February 2025.
28 February.
My lord, second paragraph. From the pedusal, my lord.
Yes.
IA application, it appears that a general relief has been sought for based on the application.
Where is IA 435?
IA 435, my lord.
What is IA 527?
IA 527, my lord, for put up. For put up.
So 435 is the
yes.
Yes, where is 435?
Yes.
Page.
It started, my lord, from page 101. Page 101, page 115, my lord, is a prayer.
Prayer is very vague.
For taking possession.
Where have you said?
Yes, from
Proceeding
restricting
further in question.
to deal with the property. Deal with the property.
Prayer has to be specific.
My lord, this is
Your prayer has to be specific,
Okay.
considering the averments made in paragraph 28, 29. Your prayer is vague. The tribunal is right.
yes, my lord, empty claim.
Not to deal. And where is the bar? During pendency of a section 17 application, is there any bar?
No.
To take possession? Because section 13(4), one of the measures is to take possession.
Yes.
Taking possession, they can
Symbolic.
take resource.
Symbolic. 13 for symbolic.
Yes.
That is, my lord, the cause of action for my lord, approaching tribunal.
Section 14.
Yes. Now, my lord, they have approached, my lord, before the, my lord, we have approached in time. Now, my lord, court
Time before.
the tribunal. Now, tribunal,
No difficulty on that.
tribunal,
Show me that during pendency, according to you, you have filed a substantive application challenging the recovery proceeding.
yes.
So recourse says taken under section 13(4). So one of the measures says to take possession.
Yes.
For taking possession, they have to approach the chief metropolitan magistrate or the district magistrate.
That they have done. That they have
They
done.
have done.
Yes.
Where is the law saying that yes, till your section 17 is decided,
No,
they cannot.
No. That is not that. But my lord, section 17 application, certain order was passed directing the bank to deal with my lord section 17 application. That is not done. Had it been dealt with, how much amount? They are claiming now the entire amount. But my lord, communication said by that time bank has received a substantial amount.
That's a dispute with regard to the section.
Yes, but they are not coming with any record that we have not got anything.
Prefer an appeal. Take
My lord,
first step.
you can give some respite, my lord.
What?
Some respect, my lord, because my lord, they are proceeding, my lord. That is the difficulty.
What they are
But
proceeding?
for taking possession of the property. My lord, it's my lord. It's my lord.
Order has not yet been passed.
Yes, that is my lord. Dear my lord. My lord,
Order has been passed.
in view of no, not yet, my lord. In view of the pendency, my lord, that may be passed any day, my lord. Last Saturday was the date.
For what?
For my lord, passing final order.
Yes.
Once it is
Order
passed,
will be passed. Authorized officer will be appointed. Local police station will be informed.
my lord,
So,
my lord,
sufficient time will pass. You can prefer an appeal and can move that.
yes, my lord.
Tribunal.
My lord, kindly give some respite, my lord, because my lord, the difficulty is, my lord, I would not have, my lord, troubled your lordship, my lord, with this application, because I know, my lord, your lordship, my lord, view in this matter. But my lord, in view of the order, my lord, had it been so, no stay has been granted.
Our Supreme Court times and again is saying no, don't interfere with this.
Yes, my lord, but my lord,
That is why. So you could have approached the appellate tribunal. When have you filed this civil division application? March 2025.
Yes.
Today we are in September.
Yes.
You could have obtained an order from the appellate tribunal by now.
My lord, appellate tribunal, if you approach, my lord, my lord, and lordship, I have, my lord, some experience, my lord, it normally, my lord, does not take any matter out of turn. That is, it will be, order will be, the date will be given, you appear on that date, order will be passed. By the time,
Approach the appellate tribunal, then come. Then come.
my lord,
Nothing will happen. In view of the alternative efficacious Somehow it came out from my. After the entirely was called on, the learned advocate for the bench. Yes.
Monthly list, item number 250.
Well, I am for the petition.
All matters are urgent and you have taken a resolution.
We are hard pressed. We are hard pressed, my lord. My lord, this, lordship, can you see from when, my lord, this matter is pending?
All right. Yes. What is this matter?
No, my lord, this is, my lord, acceptance. My lord, preemption amount, my lord, out of time.
Preemption
amount was accepted, my lord, out of time.
Yes.
Yes. So, my lord,
what did you do? You file an Parashat Rule 11.
No, no, no. My lord, I opposed, my lord. I opposed, my lord, acceptance of, my lord, the preemption amount. Barasat Eye Hospital was, my lord, referred to. That was dealt with. And, my lord, despite, my lord, giving, my lord, I must be, my lord, candid, my lord, this was taken note of. But, my lord, it was accepted, my lord, after, my lord, long period of time.
No, what happened thereafter? No, what steps did you take?
Well,
you filed an application for dismissal of the preemption.
Yes, Order 7 Rule 11.
That
Order,
I said, you said no.
Yes, Order 7 Rule 11, my lord, was taken out. And, my lord, this was accepted, my lord. Much belated, my lord, to that, my lord. Order dated, my lord, 28 June 2024.
When the amount was deposited?
Amount was.
What was the period of limitation for filing the preemption application?
No, my lord.
Or what was the last date? This preemption on what ground?
Preemption, my lord, last date was, my lord, also will find it, my lord, from the order itself.
Please give me some dates.
Yes.
What is the last date? This preemption on what ground?
My lord.
Co-sharer, Borgadar.
No, co-sharer. Co-sharer.
Co-sharer or non-notified co-sharer, what?
My lord, non-notified.
1 year.
1 year.
So it should be 1 year. What is the last date?
Impugned deed was registered on 16th April 2019.
16th April 2019.
2019.
So it should be 16th or 17th of April 2020.
2020. In the meantime, my lord,
17th of April 2020, they had to deposit the amount.
Yes. In the meantime, Corona intervened.
Last date. And when this amount was deposited?
Amount was deposited, my lord. I must. 17th April 2020 was the date limit, my lord. 1st March 2022.
1st of March 2022.
My lord,
this amount was deposited.
March 2022. You also will find it, my lord. Order
10th of March 2022.
Yes.
The amount was deposited.
Yes.
Suo writ petition was from 15th of March 2020 till 1st of March 2022.
Yes.
That period was directed to be excluded by the Honorable Supreme Court pursuant to the suo writ petition number 3 of 2020.
Yes.
So if that period is excluded,
no, my lord,
and from 1st of March 2020, the balance period of limitation or 90 days. Initially, it says 90 days. If the balance period is more than that, the longer period will be available. Yes. So let us take 1st of March, 90 days is 1st of June.
Yes.
they have deposited on 10th of March, so it's within time.
No, they made a part payment. They made a part payment. It's not a full payment.
So when the balance amount was paid,
Balance amount was paid on 10th March 2022. 10th March 2022.
that is what I am saying.
Yes.
10th March 2022, they have paid the balance amount.
But there is no provision for any part payment.
Well, please understand this. They have filed the preemption application on the last date, if I can take it other way around. The last date for filing the preemption application was on 17th of April 2020. Now, so from 15th of March, this period is extended,
Yes.
excluded. Do you have the Supreme Court's decision? Last decision. I think of 28th or so January 2022 or 2021. So by virtue of that, it was said that the entire period from 15th of March 2020, if I correctly recollect, till 1st of March 2022 shall be excluded from the period of limitation. Or in other words, that is to be added. So 17th of April 2020 falls within that time. So let us suppose here the preemptor did not file the application. Is as good as not filing the application. So he could have filed within 90 days from 1st of March 2022. So 90 days is 1st of June, March, April, 1st of June 2022. He had the time to file the preemption application. If he had the time to file the preemption application within 1st of June 2022, so all payments, here is your case, the part payment. So the entire payment was before the 1st of June.
No.
If that is so,
What I am on, my lord. My lord, had it been his case that in order to get the benefit of, my lord, the limitation, my lord, Honorable Supreme Court suo motu writ petition, my lord, the amount was deposited on 10th March within the period of limitation. But my lord, in that event, my lord, he made a part payment. He knew it very well that the amount to be deposited apart from the payment made.
what is the effect of this? Look, what's the effect of the Supreme Court order? Limitation cannot be saved. Limitation cannot be saved, and this has also been held in Gopal Sardar, Karuna Sardar, because there were divergence of view whether Section 5 is maintainable to condone the delay in filing the preemption. It has been held no, since it's an original proceeding, Section 5 is not maintainable. So the period is fixed as per the statute, Section 8. Now, what the Honorable Supreme Court has done, so in view of this period stands excluded. So if the preemptor had a right to file it, let us suppose he did not file. So this question of depositing will be on the date of filing. He has filed, let us forget for the time being. So he could have filed till 1st of June 2019. And the purport of the order of the Parashat Ayu Hospital is you cannot deposit. They are also the part payment. Part payment is hot consideration. In any case, it has to be deposited prior to the limitation being barred. Here it's being barred. Prior to that, entire amount is being deposited.
My lord, I stand corrected, my lord.
That is your only point.
Yes. Lordship,
What is the finding of the learned trial judge?
Lordship, kindly come to page, inner page 3.
Yes, right. Correct order. Correct order.
My lord,
I have not seen the order. Correct order.
but my lord, Lordship, kindly, my lord, this
Non-notified co-sharer, it has also been mentioned. Yes, what is your 151 application? Order 7, Rule 11 and the petitioner considered. What is your 151? 151 might be for dismissal.
Yes, yes, for dismissal. That is, my lord, at page 32.
Page
32.
dismissal because this amount was not paid.
The amount was not paid.
And why order 7 rule 11?
No, my lord, in the meantime, my lord, lordship kindly come to page 32.
Yes. 32.
Yes.
Yes.
My lord, paragraph 3, মহামান্য সুপ্রিম কোর্টের সাম্প্রতিক রায় মোতাবেক বর্তমান মোকদ্দমার উত্তর ভূমি ম্যান্ডেটরি প্রভিশন কমপ্লাই না করিয়া বর্তমান মোকদ্দমা রুজু হওয়া লিমিটেশন টাইমের মধ্যে প্রার্থীর লিখিত টোটাল কনসিডারেশন মানি জমা না করায়। My lord, this was filed prior to, my lord, filing, depositing the amount.
Yes, yes. Mr. Chattopadhyay, there is no dispute with regard to that. But if the period of limitation is extended, let us take another case. 1 year was the period of limitation. So 17th of April 2022 was the period of limitation. The date of the execution of the deed was 16th of April 2019. Let us assume that he filed the section 8 on 16th of June 2019, but deposited prior to, let us forget about this COVID, but deposited, let us assume the balance amount, short consideration on 1st of January 2020. He was within time. That could have been accepted as per Barashat Eye Hospital. So if that could have been accepted, now it's the extension of the period of limitation. By virtue of that, all statutes extended, central, state, including arbitration.
That is admitted position. My lord, that I cannot deny. That is admitted position. That is admitted position. That I cannot
You
deny.
admit that, you cannot dispute.
No, my lord, one thing, my lord, only one thing. Only one thing, my lord. Inner page 4.
Yes, inner page 4.
After hearing landed
I
submission.
do not find. Yes, inner page 4. Top. Yes.
Last paragraph.
Last paragraph. Yes, it starts with.
After hearing.
Yes.
When this preemption case is filed by the petitioner during the pendency of the case.
That is construction, injunction. That is injunction.
Yes. Then, my lord.
The first part ends with the previous thing. Do you have that suo motu writ petition order? You don't have.
No, my lord. That is. My lord. Yes, my lord. That is.
Suo motu writ petition এর এই অর্ডার গুলো একটুখানি বার করে রাখবেন তো।
Let me number to be mentioned tomorrow. Let me come with the order.
Passing this order. Suo motu writ petition number C, within bracket C, 3 of 2020.
That is mentioned in the order itself. Is mentioned.
That has been mentioned. There are 4 or 5 paragraphs of that. It's relevant, and it has been
quoted. It has been a portion of it.
The only relevant paragraph of that extension that is suo motu Supreme Courter. অনেক কটা অর্ডার আছে পর গুলো বার করে দেবেন তো। দিস অ্যাপ্লিকেশন আন্ডার আসুন ওই উপরেরটা সেম ঠিক আছে থাকবে। Thank you.
Abdul Matin Malik was also referred to. Abdul Matin Malik also.
Both are on the, this is
relied
the
on-
parent decision. This is the parent decision, Bharatrat Eye Hospital. After that, Abdul Matin. This is a case of adjoining owner. That's the case of co-share. Because I appeared in this matter for this.
Barashatai. Barashatai.
Yes, I appeared for Coast of Mundal before this court. I know this matter by heart. Yes. What is the other matter?
Item number 61.
My lord, in this matter, I am for the petitioners.
Yes.
This is for admission hearing. Your lordship, this is an application under Article 227 challenging the impugned order of the DRAT dated 29/4/2024,
Yes.
which is annexed as Annexure A. Your lordship kindly comes to page number 12, running page number 12. The order starts. My humble submission before your lordship is the petitioner's account in this particular case was declared as NPA under the SARFAESI Act, section 13(2), which is annexed at Annexure B, page number 20. यहाँ उंगली रखनी due to non-payment.
Yes.
Your lordship kindly comes to Annexure B, where this the notice under section 13(2), and I'll read the second last paragraph. Page number 20, your lordship.
Yes.
The second last paragraph, I'll read, lordship. What was the reason for declaring it as an NPA? Due to the total amount is given, your lordship will see that 92,17,302.30.
Yes.
On bottom of that.
Yes.
Due to non-payment of installment, interest, principal debt, the account has been classified as NPA. This was the reason taken by the bank for declaring it as NPA. Whereas I never defaulted in the non-payment, and being aggrieved, I approached before the Honorable DRAT. Now, when I appeared before the
DRT, you approached?
Before the DRT.
Yes.
Thereafter, no favorable order was passed. Then subsequently, I approached, I knocked the doors of the Honorable DRAT. When I appeared before the Honorable DRAT, the bank has taken the plea that since the mother's account, this Lohit Commercial was a bank, and his son, Deepika Rani Burgan, was the owner. Now her son was the guarantor of the said account, and her son was also having a loan account. Since her son's account was declared as NPA, so on that ground, they have declared this account also as NPA, my account also as NPA. They quoted the RBI guidelines, which your lordship kindly comes to the order, which is...
That is the order of the tribunal.
DRAT.
The TRT.
DRT order I have not annexed, your lordship. I haven't, because I am here for the order of the DRT.
But DRT's order has been affirmed, sir. You have to annex that. And where are those circulars of the RBI?
Yes, that
It says if one account is declared, you are a defaulter in one, all, it's not facility wise, it's borrower wise.
Yes, it's borrower wise. So that is what they are saying, borrower wise. So that is only, I am on, your lordship has rightly pointed out, I am on that point only, that I am not the borrower of that particular account. Once, as per the RBI circular, which I will produce, only I am before your lordship for the admission hearing, let an opportunity be given to me. As per the RBI circular, I have also mentioned that I will bring, your lordship kindly comes to page number 4 of my instant petition, which page number 4, paragraph 4. What this 2.2 says.
Now what happened? Possession has been taken.
No, your lordship, I have paid all the amounts. There is no due.
No due.
No due. I have only, the problem I am facing is that since this account was declared as NPA, right now my civil score has drastically fallen. I am not able to get any loan. Only I am on the merits that everything has been paid. Whatever the demand was by the bank, everything has been paid. But because of this wrong declaration of NPA, I have lost the credit in the market, and none of the bank is granting me the loan. And I am running, means I am not able to run my business. Only my humble prayer before your lordship at this point of time, let this matter be admitted, let an opportunity be given to me. And in this matter, I will also ask my senior counsel to appear in this matter. Only I am before you.
Husband for custody of the child under Section 6 of the Hindu Minority and Guardianship Act and Section 25 of the Hindu Guardians and Wards Act 1890. This matter is pending since 2020 and repeated adjournments have been sought for by the wife opposite party and the matter is not being heard. My lord, the child is growing up in a very unhealthy environment. That's why the husband had filed.
Application under Article 227
The two matters the combined list after recessive lordship seat.
15?
1453, 1455. Your lordship.
Yes.
My lord, matter.
How many matters? 2. I will continue with this.
My lord,
Yes.
10th December 2024, my lord, this application was initially taken up.
8th
10th
December?
December 2022.
Yes.
My lord, direction was
There was a
given.
direction to serve.
Yes, sir. My lord, I sent, it's a Reliance General Insurance Company. My lord, I served, my lord, interestingly, my lord,
Can we take up this matter in the absence of them?
one thing, my lord.
Yes.
Item return address is moved. So what I'm on at this stage, my lord, I do not want, although my lord, I filed an application for stay because my lord, they are proceeding in the meantime. Let me serve the copy of the application as well as stay, my lord, to the learned advocate conducting the case on behalf of my lord, the insurance company and
for the learned trial judge.
Well, that is because that the direction was not there. And my lord, only one thing, my lord, since I have filed an application, my lord, let the matter be matter appear under the heading application, my lord. My lord, may I sub, my lord?
What is the impugned order?
Impugned order, my lord. I am, my lord, the owner of the vehicle. My lord, the order was.
What is the nature of the impugned order?
My lord, direction was given. My lord, direction was given to me for recovery proceedings were initiated. My lord, direction was given to me for to the insurance company to recover the amount from my lord, the owner. Amount was paid, my lord, the victim. That was done. And my lord, when the recovery proceeding was done, my lord.
You are the owner.
I'm the owner of the vehicle. It ran ex parte, my lord, in the original order. Direction was given to the insurance company. You pay the amount, recover the recovery proceeding.
Now you are against that recovery.
Yes.
Why?
Now, I have, my lord, given, my lord, it ran ex parte against me, my lord, at the original proceeding. I could not deposit all the amount. Now, my lord, when I have filed this application, my lord, it was dismissed on the ground that you filed a similar application that was not entertained by, but it is an absolutely different application.
The learned advocate appearing for the petitioner submits that pursuant to the order